And we're here on the state's original petition in suit affecting the parent-child relationship. Um, Mr. Gibson would like to request that DNA testing be ordered today for both children. However, I will state that there is a valid acknowledgement of paternity for both children signed by both parties.
Welcome back to Courtroom Chronicles, where real cases meet real consequences. Today's hearing dives deep into a paternity dispute that's about to get personal. Mr. Gibson is requesting DNA tests for both children. But here's the twist. He already signed legal documents acknowledging he's their father. So what happens when emotion collides with the law? Stick around because this courtroom just turned into a DNA battleground.
To offer the evidence must be marked for identification purposes as states Exhibit A and B, the acknowledgement of paternity for Ariana Gibson and Anthony Gibson, both attached to the state's petition filed August 11th, 2025.
State's Exhibit A is admitted.
And since there are two valid acknowledgement of paternities, the state would request that Mr. Gibson's request for DNA testing be denied. But if I can take testimony from both parties, Your Honor.
You may.
I'll begin with the father. Mr. Gibson, you're requesting that DNA testing be ordered today, is that correct?
Yes, sir.
And you did previously sign acknowledgement of paternities for Ariana and Anthony, is that correct?
Yes, sir.
And so why are you requesting that the judge ordered DNA testing today?
It was because of a time that I had with one of the kids in the situation that we had. It was acknowledged that Anthony Jr. wasn't mine. So
here's where things get legally
then
interesting.
it was other
By
things
signing
that
an
popped up
acknowledgement of
around what's
paternity,
going on.
called
So
an
that's
AOP,
why I
Mr.
was
Gibson
really
legally declared
acknowledging that we
himself the
get
father.
DNA tests
In most cases, that's as
started.
binding as a court order. So, for him to request a DNA test now, he has to show valid grounds, like fraud or a serious mistake. But his reason? Emotional uncertainty after a previous relationship. Viewers, do you think that's enough to challenge a legal document? Comment below.
I'll before we go any further during the process, because I just came out of a relationship that I was staying with right before I met her, and come to find out when I took the DNA test, it wasn't my kid. So I'm just trying to figure out before we go any further during the process of any type of child support and any type of handout money that's going on, that everything is all secure.
So, Mr. Gibson, was it Miss Wilkerson who told you that Anthony Jr. Was not your child?
Yes, yes, sir.
And when did she tell you this?
When she filed that paperwork with the attorney general that same day.
Was that earlier this year?
Whenever's on file that she filed that paperwork, whenever she filed, that was said to me.
Now, this is the emotional core. Mr. Gibson claims the mother told him one child wasn't his. The very same day she filed paperwork with the Attorney General. That timing raises eyebrows. Was this statement made out of anger, or was there truth behind it? You can almost feel the tension in his voice, the fear of reliving betrayal twice.
So that's why when she filed that paperwork and I got a response back from the attorney general, I stated what she said at that time.
Okay. Um, and you also have doubts regarding Ariana as well?
No, I don't have no doubts of any one of them because of the bond and the love I got for them kids. But I just want to be secure as a man that what I'm doing and who I'm doing it for is you get what I'm saying? Like these are my kids because of the fact that I've just came out of a relationship and I was taking care of a kid and it wasn't my kid. So as a man, I'm just trying to make sure everything is dotted across the line, just like however much help she need or whatever from the.
This is heartbreaking. Despite his doubts, Mr. Gibson's affection for his children is unwavering. His words reveal a man torn between love and insecurity. And legally, that matters. Because even if DNA says otherwise, emotional bonds don't just dissolve in the courtroom. The law can determine parentage, but it can't legislate love.
Child support or whatever she needs to gain off anything she needs to do in life for them kids and for my kids. That's why I really just want to make sure.
So besides Ms. Wilkerson telling you that Anthony Jr. Was not your child, are there any other reasons um, that you are requesting DNA testing be ordered today?
No, it's just to make sure it's everything is all the way how it's supposed to be. Because of the fact that when she did make them statements, and then when I did call in and make tell the people that I was talking to at that time, it really came from a different part of her heart that like I I need to make sure. So like I said, I need to cover everything that's going on. Be- because of
Mr.
the fact
Gibson, Mr. Gibson,
I
Mr.
do.
Gibson, hold on a second. How
Uh-huh.
old are these children?
These children are 4 and 2.
Okay.
And I see them, like she give me the opportunity to see them when I do want to see them at certain times, certain days. It depends on how things are going for her during the weekend. So I mean, she do let me see my kids to have that bond. I do for my kids. It's just at the end of the day, basically, I just want to. If we gonna go through this process, I want to start this process how it's supposed to go, all the way across the board.
Mr. Gibson, when you signed the AOP, did you have any doubt?
It was a flipper of a coin.
Okay. Okay. Anything further, Mr. Leach?
Um, Mr. Gibson, did you and Miss Wilkerson previously live together?
Okay.
You said what?
Did you and Miss Wilkerson previously live together?
Yes, we stayed together all the way up to February.
Is that February of this year?
Yes, sir.
I pass the witness, Your Honor, if I could call Miss Wilkerson.
You may.
Miss Wilkerson, um, are you agreeable? Would you be agreeable to any DNA testing being ordered today?
Actually disagree with the DNA testing.
Okay. Did you ever tell Mr. Gibson that Anthony Jr. Was not his son?
Yes, I did at the moment of the time that I called Mr. Gibson and told Mr. Gibson that Anthony was not his child. Mr. Gibson had removed my child from daycare without my acknowledge and kept my child from me for a week. He also, at the time prior to removing my child from daycare, it was my child's birthday. It was also Mother's Day, and he chased me down the highway at 2 o'clock in the morning all the way to the police station.
And now, a twist. Miss Wilkerson opposes DNA testing, even though she insists Gibson is the father. That contradiction is huge. Legally speaking, if she's confident, testing could settle everything. But her refusal? That suggests strategic advice, maybe to avoid custody complications. What do you think? Is she protecting herself? Or hiding something?
And in result of that, I did not show up at a park for my child and him to meet on his birthday. So Anthony took my child for a week and was also doing a lot of stuff that was mentally draining me, like posting things on social media sites about me. And at the time, I just wanted my child back and I just wanted Mr. Anthony to leave me alone because he was just doing the most. So out of emotion, I said, that's not your child. Can you just give me my child back? Even
And
though I know 100% that Mr. Gibson is the father of both of those children.
um, no further questions, Your Honor. I pass the witness.
Ms. Wilkerson, why are you against DNA testing if you know 100% that he's the father?
I'm against it because I was advised to not do DNA testing if I don't have to, in regards of like court and custody. I was just advised it's in my best interest not to do DNA testing.
Okay. Well, I'm going to allow the DNA testing, Mr. Leach. What day are we coming back?
We will come back on February the 4th, Judge.
Okay. This case will be reset to February 4th, 2026 at 8:30 a.m. You will both need to be present on that date and at that time. If you're not present, a default order can be entered against you. Do you both understand?
Here's the pivotal moment. The judge overrides objections and orders DNA testing. That's a major win for Gibson, and a clear signal that the court values truth over tension. The results could redefine not only child support, but emotional stability for this entire family. Circle your calendars. February 4th, 2026. That's when the truth arrives.
Yes.
Yes, ma'am.
Also, you need to go to the DNA testing on the date that the agency schedules you or as close to that date as possible so that when we return to court on February 4th, we will have the results available. Does everyone understand?
Yes, ma'am. Is it going to be at the same time, or can we go at separate times and do the DNA testing?
Ma'am, I don't know. You would have to ask the Attorney General's office. I do not schedule it, okay?
Oh, yes, ma'am. Thank you.
Okay. Anything further, Mr. Leach?
Nothing further from the state, Your Honor.
Okay. Then thank you both for appearing here today, and you're both free to go.
All right. Thank you.
You're welcome. Davis and Williams. The parties in the Davis and Williams matter.
Just so there's one child before the court, Zoe Bella Davis. I'd offer as State's Exhibit A the acknowledgement of paternity for that child.
State's Exhibit A is admitted. Excuse me.
Thank you, Judge. Parties agree to be appointed as joint managing conservators of the child, with the mother having the right to maintain the residence in Dallas or any contiguous counties. Judge, parties agreed to a standard possession and access schedule. As far as the support, there's one child before the court and no other children that Mr. Davis has, so it's set at 20% of his net resources.
Now we shift gears to a more traditional child support hearing. But don't be fooled. These can get just as tense. The court is about to set support for one child based on income and percentage guidelines. Watch closely. Numbers tell stories, and these calculations often become emotional flashpoints.
Mother is to apply for or maintain government medical for the child. Cash medical support is $203 a month, beginning November 1st, 2025. Child support, Judge, at 20% is $330 a month, beginning November 1st, 2025. There is no request for any retroactive child support, medical, or dental support. Court costs would be as billed, and neither party is requesting a non-disclosure, Judge, and that's the extent of the order.
Okay. So medical support is $203 a month.
Yes.
And child support is $330.
Yes, Judge.
And that is 9% of gross, $203 a month.
Let me go and view just to make sure, Judge. Yes, 9%. So the monthly gross we have is $2,250. So it'd be $203 a month.
Okay, and it's 20% of that $2,250, right?
Yes, of the net resources.
Okay, and then how do you get $330?
Because we have his net resources at $1,651.73, and so 20% would be $330.
Okay, and the 203 is 9% of his gross.
Yes.
Okay, all right, got it. Go ahead.
If I could recall the mother, Judge.
You may.
Ms. Williams, did you hear all the terms of the order that were just stated?
Yes.
And did you understand all the terms of the order?
Yes.
And you're in agreement with all of the terms and believe they're in the best interest of your child?
Yes.
Do you have any safety concerns with your contact information being in the order today?
No.
Okay. I'll pass the witness and call the father.
You may.
Mr. Davis, can you state your full name?
Alfonso Quarry Davis.
And Mr. Davis, did you hear all the terms of the order?
Yes, I do.
And did you understand all the terms?
Yes, I have.
And with the exception of the child support amount, you are in agreement with all the other terms of the order, is that correct?
That's correct.
Okay. And so you understand that based on guideline, the child support was set to $330 a month. You understand that?
It's coming up.
But you disagree with that amount?
That's correct.
And what are you requesting for the child support to be set to?
0 and just do medical.
Okay. And so why are you asking that you not be ordered to pay any child support?
Because I take care of my daughter whenever she needs. And I also have a mutual friend in the name and all that right there.
Mr. Davis, we're having a hard time hearing you. And I think it might be because you have the headphones on and you're on Bluetooth. So can you take that off for me?
This part highlights one of the most common disputes in family court. Why pay if I already provide? Mr. Davis believes his direct support, gifts, care, time, should offset legal payments. Unfortunately, that's not how the system works. Courts rely on consistency and documentation, not verbal promises. Even generous fathers can face orders if there's no record.
See if we can hear you better. Can you say something for me?
You can hear me now?
Yes, sir. Very plainly. Thank you, sir. Go ahead. It says you're muted now, Mr. Davis. I'm sorry.
What was the question again?
So the question is, why are you asking for no child support? That the judge don't set any child support?
Because I take care of my daughter. I give her everything she needs. It was just a misunderstanding pretty much on the medical situation. It was a communication thing. So I wouldn't have no problem with actually getting medical insurance for it. But in other words, I do everything my daughter needs and see her, do everything. So that's why I say 0. And uh, I say yes to everything else just to keep everything, on a humble level.
Okay, and so just to be clear, you understand the order states that mom, Ms. Williams, is going to apply for or maintain government medical for your daughter. You're in agreement with that?
Um, until I'm able to apply and get a medical insurance, I'm in agreement with that until then, yeah. Because
Okay, you could,
like I said, just stated just now, it was just a misunderstanding on our communication. It's the reason why she don't have medical insurance in the first place.
okay. Okay, is there anything else you want the court to know as far as your request?
No.
I'll pass the witness, Judge.
Okay, then I will accept the agreed portions of this order, make the agreed portions the order of the court. I will order child support at $330 a month. Do either of you have any questions?
Yeah, I have some questions.
What's your question, sir?
If I take care of my daughter in every way, why should I have to pay some child support? Other than, you know what I'm saying? So you saying, that's like, that's
Mr.
that's like,
Davis, do you give Ms. Williams a certain amount a month every money for the support of your daughter?
I do both.
What do you mean you do both?
I give her money when
How much money do you give her a month, sir?
I give her whatever she needs.
Okay. See, that's the problem. She should be
Well,
able
what's the
to
problem? You
count
about to
on,
give her you
sir.
about to give her what she
Are
needs.
you listening to me?
$330.
Okay.
That's giving her what's the difference? I'm probably gonna like I told you,
Sir,
I got a mutual fund in my daughter's name and all that right there. So I don't understand how you just on a sudden
it
agreement
is
to a
it
one-sided
is very
situation.
commendable that you have a mutual fund in your daughter's name.
You can feel his frustration. A man genuinely trying to be a good father, clashing with a system that measures obligation by receipts. The judge reminds him that child support isn't punishment, it's structure. And when emotions meet statutes, structure usually wins. That's a hard reality many parents face.
She has to be taken care of on a day-to-day basis.
Like I said, I does that. I
Mr.
I
Davis.
do that.
Okay.
That's what you're not
Well,
understanding,
now
Judge.
you're
That's what I'm
gonna
trying to tell
do
you. I
it
do
based
that.
on child support. Now that I've made my ruling, I'm not the last word on this. What court is this out of, Miss Franklin? This is out of the 302nd District Court. That's Judge Sandra Jackson. She might have a different opinion from mine. You have 3 days to appeal, 30 days to file a motion for new trial, sir. Now that I've given you that information, do you have any questions?
Not at all.
All right, then thank you both for appearing here today, and you're both free to go.
Bye-bye.
Bye.
We're requesting a default order in which Ms. Duarte is ordered to apply for or maintain the children on a government medical assistance program. We are asking that Mr. Etier's cash medical support and child support obligations be modified to $0 per month beginning November 1st due to his incarceration. We're also asking that the court enter a child support judgment against Mr. Etier in the amount of...
This last segment is quieter, but just as impactful. The father is incarcerated, meaning he can't earn, visit, or pay. The court modifies his obligations to $0, but the debt remains. Over $56,000 in combined judgments will wait for him upon release. It's a sobering reminder that justice doesn't stop at the prison gates. Financial responsibilities can outlast freedom.
$40,194.84 as of September 30th. No judgment requested on that no payout requested on that judgment due to his incarceration. And we're also requesting a medical support judgment against Mr. Etier in the amount of $16,611.38 as of September 30th. Again, no payout requested on that judgment due to his incarceration. There is no finding of family violence in the prior order. However, due to his incarceration and the fact that we have a family violence indicator on our file, we would ask that the court grant a finding of non-disclosure as it pertains to Mr. Duarte's information out of an abundance of caution.
Then I will grant the default order. Order mom maintain government health insurance on the child. Order cash medical support and child support modified to $0 due to dad's incarceration. Order a child support judgment against Mr. Etier in the amount of $40,194.84. Order a medical support judgment against him in the amount of $16,611.38. And there will be no payouts due to dad's incarceration. Order all start dates be November 1st, 2025. And I will order a non-disclosure. Is there anything else, Mr. Talley?
That is all, Judge. Thank you.
Okay.
3 cases, 3 radically different outcomes. 1 courtroom. From DNA uncertainty to disputed child support to incarcerated obligations, every ruling underscores a single truth. Family law is emotional law. Judges don't just read statutes, they weigh lives, trust, and pain.